Okay. Is it just yourself or is it Mr. Christopher?
Mr. Christophe here and Isabella will be here as well.
Okay, that's fine. Please observe where the seats are. Don't move them. That's where you're stuck. Okay, the courtroom is now full for anybody who needs to know, so we're about to close the door.
The camera angles are changing. Mainstream, you've got the GUI controls on the wide.
All right.
We've lost the narrow, wide view.
Okay, are you ready?
Yeah, from the GUI. You know, we want to get the judge have the wide view so that he can press.
Nick? Nick, we're not going to fill it out.
Okay. And shake it.
Yeah.
Try that again.
It's because Nick has stolen the chair.
Oh,
Can you work with one of the leather ones?
yeah.
Or hang on, I'll swap you out and take this one.
That's all right.
No, take this one, otherwise you guys will not be really sorry. That's okay.
Yeah, I just realised.
That's right. Okay, ladies and gentlemen, we're going to start.
Silence, all stand.
Call the matter for judgment, please.
Crown and Leonard John Warwick.
Between 1980 and 1985, the Family Court of Australia, its judges and a practitioner were the targets of a number of episodes of extreme violence, each of which were well publicised and many of which had tragic consequences. These episodes, alongside two others, not apparently connected to the Family Court of Australia, are the 7 distinct events which make up the subject matter of this trial. On 11 May 2018, I made an order pursuant to section 132(1) of the Criminal Procedure Act that the accused be tried before a judge alone and without a jury. This order was made at the request of the accused. It was consented to by the Crown. The trial commenced before me with the presentation of an indictment, the arraignment of the accused and the Crown opening on 15 May 2018. It then proceeded, although not on a continuous basis, until the last day of submissions on 6 April 2020. This was the 207th day of the trial. I then retired to consider my verdict. At the request of the accused, and without opposition from the Crown, the accused attended and was present at his trial, including today, by audio-visual link from the custodial institution at which he is being held. My judgment extends to more than 560 pages. It sets out all of the principles of law which I have applied in accordance with my obligations. It also includes in detail all of the findings of fact which I have made and my reasons for arriving at those findings. Once I have returned my verdicts, the complete judgment will be published by being handed down to the lawyers for the Crown and the accused. It will also be uploaded to the New South Wales Case Law website, www.caselaw.nsw.gov.au, so that it can be accessed by any member of the public. Obviously, it would not be practicable for me to read out the whole of the complete judgment. That would take many days. So I will deliver these oral reasons which set out the verdicts which I have reached and a summary of the facts which have led to my decision. These oral reasons are not intended to, nor do they, replace my complete judgment. They are intended to help an understanding of the verdicts which I have reached. They are not a comprehensive statement of the conclusions I have reached, which are only to be found in my complete judgment when it is published. The accused, Leonard John Warwick, was arraigned before me on 15 May 2018 and pleaded not guilty to each of the 24 counts on the indictment. The accused has stood his trial for the following offences. A. 4 counts of murder, contrary to section 18(1)(a) of the Crimes Act 1900. B. 2 counts of exploding an explosive device which destroys or damages a building with intent to murder a named individual, contrary to section 28 of the Crimes Act. C. 1 count of placing an explosive substance into a vehicle with intent to commit murder, contrary to section 30 of the Crimes Act. D. 1 count of maliciously placing an explosive substance near a building with intent to damage that building, contrary to section 204 of the Crimes Act. And E. 13 counts of maliciously, by an explosion, causing grievous bodily harm to named individuals, contrary to section 46 of the Crimes Act. In addition to these 21 counts, there are 3 further counts charged in the alternative. No further description of those charges is presently required. The 7 separate events which make up the subject matter of this trial can be described in the following way. The first event is the murder of Stephen Blanchard, the brother-in-law of the accused, who was killed by a single gunshot to his head with a .22 calibre firearm at some time on or about 22 February 1980. The body of Mr. Stephen Blanchard was found floating in Cowan Creek to the north of Sydney on 27 February 1980. The second event is the murder of Justice David Opas, a judge of the Family Court of Australia who sat at Parramatta. At about 7:15 p.m. on the evening of 23 June 1980, Justice Opas went to answer the doorbell at the front gate of his home in Wallara. As he did so, he was killed by a single gunshot to his abdomen with a .22 calibre firearm. The third event is the bombing of the home of Justice Richard G. in Belrose at about 1:50 a.m. on 6 March 1984. The house was destroyed. Justice G, who was asleep in the front bedroom of the house, was injured. Luckily, he managed to escape from the debris with his 2 children. Justice G sat as a judge of the Family Court of Australia at Parramatta. The fourth event is the bombing of the Family Court of Australia building at Parramatta at about 10:20 p.m. on Sunday, 15 April 1984. The bomb exploded at the front of the building, causing extensive damage. Fortunately, no one was killed or injured. The fifth event is the murder of Mrs. Pearl Watson on 4 July 1984. At around 8:15 a.m, a bomb exploded at the front door of the home of Justice Raymond Watson and his wife Mrs. Pearl Watson, just as Justice Watson was leaving for work as a judge of the Family Court of Australia at Parramatta. Mrs. Watson was killed instantly and Justice Watson was seriously injured. The building was substantially damaged. The sixth event was that on the morning of Sunday, 10 February 1985. Mr. Peter Tall found an unexploded bomb in his car. Moments earlier, he had inserted the key into the ignition, but had changed his mind about starting the car. His spur-of-the-moment decision not to start his car saved his life and most probably the lives of others, because the bomb inside his car was designed to explode when the car was started. Finally, the seventh event was an explosion at the Kingdom Hall of the Jehovah's Witnesses in Casula at approximately 10:04 a.m. on Sunday, 21 July 1985. This resulted in the death of Mr. Graham Wykes and serious physical injuries to a number of other members of the Lernia congregation, which was meeting at the Kingdom Hall at the time. The Crown's case is that each of the 7 events was connected to or arose out of the course of the family law proceedings being conducted in the family court at Parramatta between the accused and his former wife, Ms. Andrea Blanchard. It will be seen that the first 2 events occurred about 4 months apart in 1980. The other 5 events occurred over a period of about 15 months in 1984 and 1985. The 2 events in 1980 were carried out with the use of a .22 calibre firearm. In 1984 and 1985, all events involved the use of what has been variously described as an improvised explosive device, or else a bomb. These terms are interchangeable. The Crown's case is that the accused was the perpetrator of each event. In particular, the Crown argues that his motive was a desire to retaliate against those who in the course of the proceedings interfered with and adversely impacted upon his access to his daughter. The accused denies being the perpetrator of any of the events the subject of the trial. As I have said, there are various principles of law which I am obliged to and which I have applied in my deliberations. It is appropriate to note 2 of them at this time. The first legal principle is that it is for the Crown to prove the guilt of the accused beyond reasonable doubt. This means that the Crown must prove each element of each offence, but not every fact relied upon, beyond reasonable doubt. The accused is presumed to be innocent and has no onus to establish that he is not guilty. The Crown case against the accused in this trial is a circumstantial one. That is because no one saw the accused commit the offences, and there is no direct evidence which proves that he is the perpetrator of the events. Because the Crown case is a circumstantial one, the second principle of law which must be applied to my consideration is that I cannot return a verdict of guilty upon any charge unless the circumstances are such as to be inconsistent with any reasonable hypothesis other than the guilt of the accused. To enable me to be satisfied beyond reasonable doubt of the guilt of the accused for any offence, the Crown needed to persuade me that the guilt of the accused is a rational inference, and that it is the only rational inference that the circumstances would enable me to draw. The Crown is required to exclude all reasonable hypotheses consistent with the innocence of the accused. Further, because it is a circumstantial case, I needed to consider and weigh up all of the circumstances established by the evidence in deciding whether the Crown has proved its case. That is, I must not look at the evidence in a piecemeal fashion, but rather to consider it as a whole. It is first appropriate to consider the connection of the accused to each event the subject of the trial. This forms the Crown's case concerning the motive of the accused. The Crown is not obliged to prove the existence of any motive in the accused to do what has been alleged. Motive is not an element of any of the offences giving rise to the counts on the indictment. However, the existence of a proved motive is a circumstance which may be taken into account as being relevant to whether the accused committed the offences charged. Evidence of motive is often regarded as being relevant to the question of whether an accused has committed an offence, because common sense and experience suggests that people are more often killed for a reason than for no reason at all. The Crown's case is that the accused's motive to perpetrate each event arose out of and was wholly linked to the ongoing family law dispute between him and his former wife, Ms. Blanchard. The accused and Ms. Blanchard were married on 19 October 1974. Their daughter Trudy was born in June 1978. The evidence suggests that the relationship was turbulent, particularly after the birth of their daughter. On 17 March 1979, Ms. Blanchard left the matrimonial home with Trudy, who was then about 9 months old. Proceedings in the Parramatta Registry of the Family Court of Australia were instigated by Ms. Blanchard not long after this. The family court proceedings, which began in 1979 and were finalised in 1986, spanned the whole of the period during which the 7 events which are the subject of this trial occurred. The proceedings involved 2 main subjects of dispute: a custody dispute which continued to affect the accused's access to Trudy, and a property dispute concerning primarily whether the former matrimonial home in which the accused lived ought to be sold. The Crown's case is that the target of each event was involved to some degree in the accused's family law proceedings, and that each target acted in a way contrary to the accused's interests in that matter. For most targets, that they were involved in the proceedings is self-evident. Justices Opas, G and Watson each presided over the matter at key points in the proceedings. The family court building at Parramatta was where the matter was being heard. Mr. Stephen Blanchard was the brother of the accused's then wife, with whom the accused was having his family law dispute. The connection of the Lanier Congregation of Jehovah's Witnesses, who met at the Kingdom Hall in Casula, to the proceedings is alleged to be that, in 1985, members of the congregation assisted Ms Blanchard and Trudy to leave Sydney and move to a location unknown to the accused in Foster. This had the effect of denying the accused his access to Trudy as allowed by the family court orders. Mr Peter Tall, who found the bomb in his car outside his house, had no connection to the accused or to the family law proceedings. However, Mr Tall was a tenant of a house that had been owned for many years and only recently been sold by Mr Gary Watts, who was the solicitor for Ms Blanchard in the proceedings at the time. The address was still listed in the white pages as Mr Watts's address. I have been satisfied by the Crown that Mr Gary Watts was the intended target of the bomb in Event 6. The Crown argues that each of these targets acted in a way which was adverse to the interests of the accused at some point in the family law proceedings. Again, for some targets, this is clear. Members of the Lanier congregation clearly acted adversely to the accused's interests by assisting Ms Blanchard and Trudy to leave Sydney and move to a location unknown to the accused, and so prevented the accused from seeing his daughter. Similarly, the Parramatta Family Court was the location where orders restricting the accused's access to his daughter were made. For each of the judicial officers, the accused argued that the orders made in his matter were routine and that in the course of the proceedings, orders both for and against the accused were made. Ultimately, the accused submitted that there was no objective motive for him to target any of the three judges. Justice Opas presided over the proceedings on 8 separate occasions between 30 April 1979 and 22 May 1980, and was the first judge to preside over the accused's matter at the Parramatta Registry. Over the course of these hearings, Justice Opas made a number of remarks that were highly critical of the accused. He ordered supervision of the accused's access to Trudy, and on one occasion suspended the accused's access to Trudy indefinitely. I am satisfied that Justice Opas would have been perceived by the accused as having acted adversely to his interests. Justice G presided over the proceedings on 5 separate occasions prior to the bomb exploding at his house. The orders made by Justice G in 1981, July 1983 and January 1984 did not favour the accused and would have been seen by him as contrary to his wishes and interests. Despite the accused wishing to stay in the matrimonial home, the sale of the house was ordered by Justice G, and when the accused did not cooperate with the order for sale, Justice G supplemented the original order with further orders to make the sale of the house more readily achievable without the assistance of the accused. The accused wanted unrestricted access to Trudy at a time convenient to him, including taking her for trips away from Sydney. Justice G reduced the access of the accused from a minimum of 2 days per week to a minimum of each alternate Saturday and any other access by agreement. The accused was restrained by Justice G from attending Trudy's school and from travelling with her outside the Sydney metropolitan area without the written consent of Ms Blanchard. If he kept Trudy for a period outside of his agreed access times, Justice G authorised the removal of Trudy from the accused by permitting the use of a warrant addressed to the Australian Federal Police. The proceedings were also listed before Justice G on the morning that the bomb exploded at his home. The applications which were to be heard that day placed the accused at risk of a complete suspension of his access to Trudy. This suspension would then, after a period of time, become a fixed period of access for 1 day per fortnight with nothing more. This was a significant diminution from the minimum period specified of access which the accused enjoyed prior to that time. Justice Watson presided over the proceedings on 6 separate occasions before his home unit was bombed. However, there were only 2 occasions when Justice Watson dealt substantively with the proceedings. On one such occasion, Justice Watson and the accused had a testy exchange in which Justice Watson threatened to proceed as if the accused did not exist. On the second occasion, Justice Watson fixed the accused's access to Trudy at only 1 day a fortnight. As well, he made an order which empowered officers of the AFP to retrieve Trudy from the accused if she was with him at any time outside the specified access times. The consequence of this was that the accused could not have access to Trudy at any time that merely suited him. Ms. Blanchard was not obliged to provide him with any access over and above the time fixed by the orders of Justice Watson. Mr. Watts was the solicitor who had the primary carriage of the matter for Ms. Blanchard when she engaged the firm Ledlin, Watts and Associates. He commenced acting for her on 9 November 1982 and continued until 15 February 1985, when he ceased to act for her. He ceased to act immediately after the bomb was found in Mr. Tall's car. In reviewing the family court file, which was in evidence, it is clear that Mr. Watts and those in his employ had a determined approach in looking to obtain orders on behalf of Ms. Blanchard with respect to both the sale of the former matrimonial home and the restriction of the accused's access to Trudy, focused on the accused's behaviour. In particular, Mr. Watts used the accused's dereliction of the court's orders as the basis for obtaining the orders which were adverse to the accused. Consequently, for each of events 2 through to 7, I am satisfied that each intended target was involved in the accused's family law matter in some way and acted in a way that was adverse to the accused's interests. I am not so satisfied in relation to event 1, the murder of Mr. Stephen Blanchard. Mr. Blanchard, the brother of Ms. Blanchard, was not as clearly involved in the matter as other targets. At the time of Mr. Blanchard's murder, the proceedings had not been on foot for long. There was one incident in December 1979 where Ms. Blanchard said that Mr. Blanchard drove her to the accused's house and assisted her in trying to force the accused to give Trudy back. This was said by the Crown to constitute Mr. Blanchard involving himself in the matter in a way adverse to the accused's interests. However, there is little by way of contemporaneous evidence upon which one can draw the inference that Mr. Stephen Blanchard was actually involved in the confrontation with the accused on that day. None of the court hearings that followed, nor the police interviews with Ms. Blanchard, nor the family court counsellor's report following the incident made reference to Mr. Blanchard as an involved party. This is despite the incident being mentioned on a number of occasions. I am satisfied that what occurred was a confrontation that primarily involved the accused and his former wife, Ms. Blanchard. Without more, I fail to be convinced that a motive existed in relation to Mr. Blanchard arising from any alleged involvement in the accused's ongoing family dispute with Ms. Blanchard. I am therefore satisfied that a motive existed for the accused in relation to events 2 to 7, but not event 1. It is now appropriate to consider the Crown's case in relation to each event. I will commence with a consideration of event 7, as this is the event upon which the Crown bases an argument regarding coincidence and tendency reasoning for the other 6 events. This will be dealt with after the consideration of event 7. The Crown case in relation to event 7 is that the accused constructed an improvised explosive device using a high explosive, probably molinite, and then placed that device under the platform at the Kingdom Hall at some time on the night of Saturday 20 July 1985 or early in the morning of Sunday 21 July 1985. The accused denied constructing, planting or detonating the bomb at the Kingdom Hall. As I have already mentioned, the Crown case is that the accused was acting in retaliation against the Lanier congregation for the role some members of that congregation played in assisting his ex-wife, Andrea Blanchard, and their daughter Trudy to move from Sydney to a place on the mid-north coast of New South Wales without his knowledge or consent. This had the effect of preventing the accused from exercising his court-ordered access rights to Trudy. A significant part of the Crown's case relates to and centres upon a break-in that occurred the week before the bomb exploded. On the evening of 13 July 1985, or the early morning of 14 July 1985, exactly 1 week before the bombing, there was a break-in at the Kingdom Hall. A window towards the back of the hall was broken and wound open. However, nothing was taken and no further damage was inflicted on the hall other than the broken window, which facilitated access for an intruder. The intruder did not take anything from the hall, but did break the window pane to enable access to occur. The intruder, however, shed blood onto various parts of the hall and the things within it. Members of the Lanier congregation found blood on the broken glass, the curtains and the carpet under the broken window, as well as a trail of blood which led behind the platform in the hall. Blood had been dropped onto some stored cardboard boxes. The members of the congregation cleaned up the blood where possible, including cleaning the curtains and the blood on the parts of the floor that could be mopped up. Blood on the carpet and on the cardboard boxes had yet to be cleaned by the time of the explosion the following week. The relevance of this first break-in was that, on the morning of the explosion, members of the Lanier congregation noticed the same window, which had been repaired in the intervening week, was broken in the same spot again. There was no blood left on this occasion. Again, nothing was stolen or appeared disturbed within the hall other than the broken window. After the explosion at the Kingdom Hall, investigating police asked members of the congregation if there was anything which could be of assistance to them at the bomb site. Police were informed of the previous break-in and were shown the respective blood-stained carpet and cardboard, which were each intact under the rubble. Investigating police took each of these items to form part of their investigation. The Crown argues that the intruder on both occasions was the same person, and that person placed the bomb on the second occasion. On the Crown case, the first occasion was a reconnaissance to find out how the Kingdom Hall could be entered covertly and where a bomb may be placed without being discovered. This same method of entry was then utilised on the second occasion to enter the Kingdom Hall and to plant the bomb under the platform. The Crown relies on coincidence reasoning to argue that the two break-ins were causally linked. That is to say, they did not happen by coincidence. In my assessment, the similarities are of such a nature that it is highly improbable that the successive break-ins to the Kingdom Hall occurred by mere coincidence. In particular, the break-ins each occurred between late Saturday evening and Sunday morning on successive weekends preceding the meeting of the same congregation. The same southeastern window was broken on each occasion to facilitate entry, and on each occasion nothing was taken and nothing was interfered with. The trail of blood from the first break-in shows that the intruder walked towards the back of the hall to the open area at the rear of the platform. I am satisfied that the intruder must have walked the same or a substantially similar path on the second occasion in order to position the bomb under the platform from the rear. Ultimately, I am satisfied that both of the break-ins were committed by the same intruder and were linked by the intention of the intruder. On the first occasion, the intruder was carrying out a reconnaissance to test the best method of entry and to find where it may be possible to place a bomb which would be concealed from members of the congregation. The second break-in was to achieve the objective of placing the bomb beneath the platform. The outstanding issue is whether this intruder on both of these occasions was the accused. The Crown case that the accused was the intruder relies upon two circumstances, both arising out of the blood-stained carpet and cardboard. First, a blood group test was performed within a few days of the explosion in 1985, which found that the blood on the carpet and cardboard was the same blood group as that of the accused. Secondly, DNA profiles, which were developed from the bloodstains on the carpet and cardboard in 2013 and 2017. The Crown accepts that proof that the accused was the intruder of the first break-in is an intermediate fact, which means that it must prove this fact beyond reasonable doubt. DNA experts for both the Crown and the accused agreed, with the highest level of scientific certainty presently available, that the DNA profile found on both the carpet and cardboard in 2013 and 2017 was that of the accused. The Crown's experts said that for a number of the profiles which were identified, that there was only a 1 in 100 billion chance that the profile was not that of the accused. However, the accused raised the hypothesis that the DNA profile found on the carpet and cardboard was not sourced from the blood which came onto the items during the first break-in, but rather that the DNA profiles were transferred onto the carpet and cardboard at some later time. The DNA expert called by the accused confirmed that this type of secondary transfer was theoretically possible. Given that my finding in relation to the DNA evidence is central to the proof of the intermediate fact, the Crown needed to prove to me, beyond reasonable doubt, that the DNA found on the carpet and cardboard was sourced from the blood stains on the items which appeared on them during the first break-in. In considering that question, I decided that I needed to be satisfied of the following four matters in order to be satisfied beyond reasonable doubt that each DNA profile sourced from the items were profiles left by the intruder on 13 or 14 July 1985. First, that the bloodstains found on the carpet and cardboard were deposited on those items by the intruder on 13 or 14 July 1985. I am satisfied on the basis of the observations of the members of the congregation who discovered the first break-in and the surrounding facts and circumstances that the blood is that of the intruder who sustained a lacerating injury and who consequently shed blood onto the carpet inside the Kingdom Hall near the broken window and onto the pile of cardboard boxes stored there. Secondly, that the blood-stained items of carpet and cardboard were still present in the Kingdom Hall to be collected by police after the explosion on 21 July 1985. The unchallenged evidence which I have accepted was that no attempt was made to clean the blood from the carpet in the area between the southeastern broken window and the platform. The pile of cardboard boxes were not removed at any time between 14 and 21 July 1985, and none of the cardboard boxes were destroyed or burnt at that time. This was supported by the evidence of a number of members of the Lanier congregation who each said that they observed on the morning of the explosion that the carpet under the window, which had been broken a second time, remained stained with blood from the previous week, but there was no fresh blood from the second break-in. Thirdly, that both the carpet and the cardboard had an unbroken chain of custody from when they were collected by police investigators in 1985 up until the time in 2013 and 2017 when they were tested for DNA profiles. There was extensive evidence on this point in the trial, which is dealt with in far greater detail in my complete judgment. In short, I am satisfied beyond reasonable doubt that the cardboard and carpet collected in 1985 from the Kingdom Hall was the same cardboard and carpet sent for DNA testing at the Forensic and Analytical Science Service in 2013 and again in 2017. My consideration of this point included personally observing the pieces of cardboard and carpet. Ultimately, I have been satisfied that the evidence can account for the continuity of these items between their collection from the Kingdom Hall in July 1985 and when they became exhibits in this trial. Finally, whether the DNA profiles identified by Dr. Bruce at the Forensic and Analytical Science Service in 2013, which matched the DNA profile of the accused, came from the blood deposited during the break-in on 13 or 14 July 1985. Once again, this is a matter upon which there is detailed reasoning and consideration in my complete judgment. In short, I am satisfied that the DNA profile came from the bloodstains and not from some other source. I accept Dr. Bruce's opinion, given at trial, in which he stated the DNA profiles were sourced from the bloodstains. This opinion accords with the facts, does not strain credulity, and by the application of common sense, accords with what is likely to have happened. Blood is a rich source of DNA and would be expected to still turn up a profile 28 years after it was shed. 4 of the bloodstains on the cardboard and 3 bloodstains on the carpet returned a DNA profile. 6 of these profiles matched that of the accused, and 1 returned a mixed profile consisting of the profile of the accused and another person. Conversely, parts of each item which do not appear to have been bloodstained were tested as controls, and each of them did not return a DNA profile. This tells against a transfer of DNA onto the carpet and cardboard, as the DNA profiles accord with where the stains are found. Furthermore, there was no evidence before me at trial that would allow me to draw a reasonable inference that DNA was transferred onto the items. The accused could not reasonably point to any other source of his DNA to which police or anyone else would have had access in order to carry out the secondary transfer of DNA of the accused onto the carpet and cardboard. Although there were submissions concerning handkerchiefs of the accused, which were seized by police in 1985 as a possible source of DNA, I do not accept that this is a reasonable inference. There is a contemporaneous document, being a running sheet, which records that these items were destroyed in August 1985. This destruction occurred before DNA technology was used in New South Wales during police investigations. It is nonsensical to say that at a time when DNA was not something that could be tested for, police transferred DNA onto an item in the hope that at some future time DNA on that item would be discovered. I reject any submission to that effect. As well, the evidence describing the steps necessary to enable a secondary transfer of DNA to take place make it so unlikely to be able to be successfully achieved as to make the secondary transfer hypothesis in the circumstances of this trial entirely fanciful. This is particularly when one considers the risk such a transfer poses for the integrity of the DNA evidence itself. Finally, even if it were possible for someone to access the items, remove any DNA that exists from the bloodstains, and transfer the accused's DNA exactly onto those bloodstains, a dubious proposition in my view in the first place, there was no motive advanced for any person to engage in the secondary transfer of the DNA of the accused onto the items in police custody. No person was identified or suggested by the evidence as being capable of or likely to have carried out the secondary transfer exercise. It should not be overlooked that in the broader context there was extensive legal and personal risk for any person or persons involved in effecting a secondary transfer in exchange for no identified personal benefit or gain. There is quite simply no evidence that any person would have had any motivation to engage in a highly risky and illegal exercise where they deliberately transferred the DNA of the accused onto items which would become exhibits. For all of the above reasons, I am satisfied beyond reasonable doubt that the secondary transfer hypothesis advanced by the accused is not available on the evidence. Consequently, I'm satisfied beyond reasonable doubt of the following matters. 1. That the blood found on the carpet and cardboard in the Kingdom Hall by members of the Leonard congregation on the morning of 14 July 1985 was blood that was shed by the intruder who broke into the hall on 13 or 14 July. 2. That 1 week later, on 20 or 21 July 1985, the same intruder broke into the Kingdom Hall and placed a bomb under the platform. 3. That the blood-stained carpet and cardboard pointed out to investigating police by members of the Leonard congregation after the explosion was stained with the blood of the intruder during the first break-in. 4. That the blood on the 2 items was tested in 1985 and was identified as being from a person who has the same blood group as the accused. 5. That the carpet and cardboard were kept in police custody unless they were being scientifically examined and tested in 1985, 2013 and 2017 at all times between their collection at the scene of the bombing at the Kingdom Hall in 1985 and their tender in this trial. 6. That the DNA profile found on a number of different areas of the carpet and the cardboard was DNA extracted from the blood stains on those items. And 7. That these DNA profiles matched the DNA profile of the accused at a level of confidence which presently represents the highest available extent of scientific certainty. Before coming to a conclusion regarding Event 7, I have considered other relevant factors which arose on the evidence. First, a circumstance weighing in favour of the accused being responsible is that the accused had the opportunity to carry out the bombing. The accused lived within a short walking distance of the Kingdom Hall. He was not rostered on at work with the New South Wales Fire and Rescue Service, and I am satisfied he was not undertaking a practice called recall with a different fire station, which is a practice I am satisfied generally existed, but I am not satisfied it was undertaken by the accused at any relevant time. Secondly, there was no other person identified on the evidence as having a sufficient motive to blow up the Kingdom Hall or to cause harm to the members of the Leonard congregation. This is a circumstance weighing in favour of the accused as the offender. Third, the accused raised the circumstance that he did not have the kind of wounds which correlate to an injury causing the observed blood loss after the first break-in on 13 or 14 July 1985. The accused pointed to the fact that when he was strip-searched on 30 July 1985 by 2 investigating officers, no wounds were observed. This is a circumstance weighing against the accused as the offender. However, I am not satisfied that a cursory examination by 2 officers with no medical training, undertaken 16 days after an injury was sustained, displaces a conclusion that such a wound was in fact sustained. The evidence suggests that a period of 16 days is a sufficient time for a wound to heal to a point where it may not be visible to an untrained eye. Furthermore, there is evidence from 2 firemen that when the accused returned to duty at the Liverpool fire station on 15 July 1985, he had a number of facial wounds. Consequently, any submission concerning the absence of observable wounds on 30 July 1985 did not lead me to having any reasonable doubt about the accused being the perpetrator. Another circumstance that the accused pointed to as raising reasonable doubt is that there is no evidence in the trial that the accused had any qualification or experience in dealing with explosives. He did serve for 2 years in the Australian Army. However, after initial recruit and trade training, he served the balance of his time as a cook. No formal training in explosives is noted in his Army records. The Crown pointed to a number of sources of information concerning explosives that were publicly available during the time period covering the events the subject of this trial. Those sources included a book which was found in the accused's home by police in 1984. The experts on the subject of explosives called by the accused agreed that there were many publicly available sources from which a person could obtain sufficient knowledge about the creation and detonation of a bomb, including those made freely available by manufacturers, and as well copies of US Army manuals on booby traps, improvised explosive devices, and methods of detonation of bombs. I have been satisfied by the Crown that sufficient information was publicly available, such as would have allowed the accused to inform himself about making a bomb. The fact that the accused has not been proved to have had any training or experience in the use of explosives is not of itself and without more sufficient in all of the circumstances to mean that the Crown has not proved that he is the perpetrator of the Kingdom Hall bombing. Finally, the accused did not concede that the injuries sustained by the named victims in counts 12 to 24 of the indictment amounted to grievous bodily harm. After a consideration of the contemporaneous medical evidence in relation to each victim, I am satisfied beyond reasonable doubt that the injuries sustained by each named victim amounted to grievous bodily harm. In conclusion, I am satisfied that the Crown has proved beyond reasonable doubt that the accused was the person responsible for placing a bomb under the platform at the Kingdom Hall at Casula on 20 or 21 July 1985 and for its detonation on the morning of 21 July 1985. Based on my findings in relation to Event 7, I now propose to consider whether the Crown can rely upon coincidence reasoning and tendency evidence as circumstances in the proof of Events 1 through to 6. I will first consider coincidence reasoning. Coincidence reasoning relies upon evidence to show the improbability of two or more events occurring coincidentally as a circumstance which can be considered as relevant to the guilt of an accused. That is to say, I may consider that two or more events were causally linked and did not occur merely by coincidence as a relevant circumstance in the proof of the identity of an offender for each event. In this trial, the Crown argues that events 1 to 7 did not happen by coincidence and are causally linked. Specifically, the Crown argues that there are similarities which establish that the offender for each event was the same person. Given that I have found the accused responsible for Event 7, the Crown submits that coincidence reasoning is a highly relevant circumstance in my consideration of whether it has proved that the accused is the perpetrator of each of the events 1 to 6. I am satisfied to a high degree of probability that each of events 2 to 7 were not separate events perpetrated by unconnected individuals and which happened coincidentally. I am satisfied that they were causally linked and perpetrated by the same individual. The Crown, I am satisfied, has proved that it is entitled to rely on coincidence reasoning as a circumstance with respect to each of events 2 to 7. This reasoning tends in favour of the prosecution case that one person perpetrated each event, and that on the basis of my finding in event 7, this was the accused. This finding was based principally on the following circumstances, each of which I am satisfied are established on the evidence. First, as I have already mentioned, each of the events occurred during the course of the accused's family law proceedings, and no similar events occurred after the proceedings concluded in 1986. The intended targets were each connected with the proceedings, and for events 2 to 6, each intended target had some direct relationship with the proceedings which was adverse to the accused's interests. Secondly, the extent and nature of the violence seen in each event was similar. Each of the events involved an attack of violence which carried with it an intention to kill or else a reckless indifference to human life. Bombings of the kind seen in events 3 to 7 were generally rare in Australia and had never occurred where the target was a court or a member of the judiciary. As well, the violent nature of the shooting in event 2 had never previously been perpetrated against a member of the judiciary in Australia. This was a distinct period of violent offending against judicial officers of the same registry of the same court in a way not seen before in any court in Australia, let alone concentrated in one registry of an Australian court. Thirdly, the bombs used in events 6 and 7 shared distinct similarities. The detonators used in both events 6 and 7 were each an ICI manufactured copper cup instantaneous electric detonator manufactured prior to 27 May 1981. In each of events 6 and 7, the same high explosive was used, namely a commercially produced product from ICI called molinite. That combination had not been reported previously to the Australian Bomb Data Centre. Fourthly, there was no public claim of responsibility for any of the events by any individual or group, nor were any of the events identified as advancing or else being associated with any particular cause. And finally, leaving aside events 4 and 7, each of the events took place in the home of the individual, targeted where they were entitled to feel safe and secure. In the case of event 7, the bombing took place in the Kingdom Hall, where the members of the Lanier congregation of the Jehovah's Witnesses were entitled to feel safe and secure in the exercise of their faith. I am not satisfied that there is sufficient similarity between event 1 and the other events to hold that event 1 could not have occurred as a coincidence with the other events. This is because I am unconvinced that the Crown has proved that there is any connection of any substance between the actions of Stephen Blanchard and the family law proceedings between Ms Blanchard and the accused, of a kind necessary to establish a motive on the part of the accused to murder Mr Blanchard. As well, I have found that the whole nature of the murder of Stephen Blanchard is much more complex, particularly with respect to dealing with and disposing of his body, than that which occurred in the other events. In each of the other events, no attempt was made to do anything with the bodies of the victims or intended victim, other than to leave them at the scene of the crime. Mr Blanchard's body was taken over 50 kilometres away from his home for a rather complex disposal which involved the need to handle and move the body on a number of separate occasions. Put differently, whilst the murder of Stephen Blanchard was an event of significant violence, the strength of the connection to the family court proceedings is elusive, and the differences surrounding how the victim and his body were dealt with means that there are not sufficiently strong similarities between event 1 and other events to disregard coincidence as a reasonable explanation for what occurred. However, this finding does not mean that the Crown case fails on event 1. It simply means that in proof of that case, the Crown will not be entitled to rely on coincidence reasoning to implicate the accused. In summary, I am satisfied that events 2 to 7 are causally linked. Coincidence reasoning is therefore a relevant circumstance for my consideration of events 2 to 6. I will now move to my consideration of the applicability of tendency evidence. Tendency evidence is evidence that establishes a person has or had a tendency to act in a certain way, or a tendency to hold a particular state of mind. If such a tendency is proved on the evidence, it is a relevant circumstance to be considered in proof of the Crown case that the accused is the perpetrator of the events. The Crown submits in this trial that if the accused is responsible for event 7, this establishes that the accused had two tendencies. First, a tendency to hold animosity, including an intention to kill, towards individuals or institutions who act in such a way as to adversely affect his access to his daughter. Secondly, a tendency to commit violence against individuals or institutions who act in such a way as to adversely affect his access to his daughter. On the basis of my finding in relation to event 7, I am satisfied that the Crown has established the accused held these two tendencies as at July 1985. It is now necessary to assess, in light of the previous findings and conclusions, whether the Crown has proved, beyond reasonable doubt, that the accused was the person who murdered Justice Opas on Monday, 23 June 1980 at Wallara by shooting him. This is event 2. On 23 June 1980, at around 7:10 p.m, the Opas family sat down to eat their evening meal together. Just as they began their meal, the front doorbell sounded, indicating that there was a person at either the front door or else at the front gate of the house. Justice Opas left the table to answer the doorbell. After her husband had been gone from the dinner table for about 5 minutes, Mrs. Opas became concerned at his absence and went outside to investigate. She found him lying on his back, unconscious, with a bullet wound to his abdomen. It is beyond question that Justice Opas was murdered by being shot when he answered the front gate bell at his home in Wallara. It was obviously a targeted attack. The killer intended to murder the judge and did so in a very short space of time. The killer did not need to and did not enter the property. Nothing was stolen. The judge was not seized whilst alive to be used as a hostage for ransom or some other purpose. The motivation for the murder was not theft or financial gain or some other malevolent intent. In short, the intent was clearly to murder Justice Opas. The Crown has satisfied me that there was nothing about the personal life of the judge or his wife which could have given rise to the murder. I am satisfied that Justice Opas and Mrs. Opas were a happily married couple with 2 young children who lived life in a usual and ordinary manner. The way in which they lived their life would not cause others to feel ill will towards them. I am well satisfied that Justice Opas, a member of the Family Court of Australia who sat at Parramatta, was targeted because of his role and conduct as a judge of that court. I am satisfied this would have been by a litigant who felt antipathy towards him because of what he had said or done, or both, in the course of carrying out his role as a judge. The accused's motive as one such litigant was well established by the Crown. It was very clear that soon after separation from Ms. Blanchard, the accused was determined to have access to his daughter when it suited him, and to obtain full custody. Justice Opas made a number of orders which significantly impacted upon the accused's freedom of access to his daughter Trudy. In particular, I am satisfied that the hearings in April and May 1980 would have produced feelings of deep resentment towards Justice Opas on the part of the accused, and he would have felt that he was being treated unfairly. Justice Opas completely suspended the accused's access to his daughter for a 4-week period without providing any reasons. Justice Opas then refused to ameliorate the effect of that suspension of the access order. Having regard to the listing of the proceedings from the time they were transferred to the Family Court up until 20 May 1980, I am satisfied that the accused would have anticipated that the custody and access issues would continue to be presided over by Justice Opas, as well on the probabilities, the application dealing with the matrimonial property. The Crown has satisfied me that the accused had a strong anger towards and antipathy towards Justice Opas, arising out of the proceedings being heard at the Parramatta Registry of the Family Court, which would provide a motive for his murder. I am further satisfied that at lunchtime on 20 May 1980, which was the last day that the proceedings came before Justice Opas, the accused told Ms. Blanchard that Justice Opas was not going to be around much longer. Upon questioning this statement further, Ms. Blanchard was told by the accused that Justice Opas was not going to be there at all. To me, this was the accused knowingly and prophetically predicting the death of Justice Opas, who was murdered just over 4 weeks later. I regard these statements made by the accused to Ms. Blanchard as indicating that by 20 May 1980, he had come to the conclusion that Justice Opas was going to be murdered. There was no other basis available upon which it could be said that Justice Opas would no longer be around at all, and that he would not be presiding over the matter between Ms. Blanchard and the accused. The Crown has persuaded me that there was no one else identified on the evidence before the court who murdered Justice Opas. Put differently, I am satisfied that the Crown has proved that there is no reasonable hypothesis consistent with the innocence of the accused in respect of the murder of Justice Opas. The accused was not at work at the Fairfield Fire Station at the very time of the shooting. There was more than sufficient time for him to drive his car from Fairfield to Woollahra at the end of his shift on 23 June 1980, park his car and to confront Justice Opas at the front gate of his house at around 7:15 p.m. The accused was generally familiar with the local area where the murder took place, having lived within a few kilometres of Justice Opas's house for a number of years. I have been persuaded that the accused was capable of carrying out the murder by shooting. He was an experienced shooter, owned a number of firearms, loaded his own ammunition, and was obviously familiar with all aspects of the handling of firearms, including those of a .22 calibre. The combination of all these circumstances, together with the context of all of the evidence that the Crown has proved and relied upon, including the absence of any other reasonable hypothesis consistent with the innocence of the accused, have persuaded me beyond reasonable doubt that the accused murdered Justice Oppas. I have reached this conclusion without reference to coincidence, reasoning, or tendency evidence. I am entitled to, on the basis of coincidence reasoning, take into account the circumstance that the accused is responsible for the offences relating to Event 7, and that there is a causal link between Events 7 and 2. If I were to do so, then such proved circumstance significantly adds to and strengthens the Crown's proof beyond reasonable doubt that the accused is guilty of the murder of Justice Oppas. I note that I have not taken into account at all the tendency evidence relied upon by the Crown in relation to Event 2. As the tendencies were established in relation to Event 7, which occurred in July 1985, and Justice Oppas was murdered in June 1980, I find it inappropriate to reason that such tendencies necessarily existed 5 years earlier. I have therefore not used tendency evidence in my consideration of Event 2. I find that the Crown has satisfied me beyond reasonable doubt that the accused is responsible for the offence of the murder of Justice Oppas at Woollahra on 23 June 1980, as set out in Count 2 on the indictment. It is now appropriate to consider whether the Crown has proved the guilt of the accused beyond reasonable doubt with respect to the placing and detonation of the bomb at Justice G's home. Justice G lived with his wife and 2 high school-aged children in Belrose. Mrs. Helen G was not in the house on the evening of 5 March 1984, as she was in hospital. On the evening before the bomb exploded, Justice G retired to bed after his daughter at about 9:20 p.m. His son retired to bed at about 10:20 p.m. All was well at that time. At about 1:50 a.m. there was a loud explosion which woke Justice G and his children. They each managed to get out of the house and make their way to a neighbour's house. It was immediately apparent that significant structural damage had occurred. The police and ambulance were called. As I have already said, I am satisfied that the accused had a motive to target Justice G. I am also satisfied that Event 3 did not occur by coincidence with Events 2 to 7, and there is a high likelihood they were committed by the same offender. I have been satisfied that the accused was the person responsible for the murder of Justice Oppas and the explosion at the Kingdom Hall, Events 2 and 7. This is a circumstance which I regard as being of considerable significance in pointing to the guilt of the accused for this event. Furthermore, I consider the 2 tendencies established by the Crown as relevant in my consideration of Event 3. The tendencies are established as existing both in 1980 by the murder of Justice Oppas and in 1985 by the bombing of the Kingdom Hall. I am therefore well satisfied that the accused was a man who had a tendency to hold animosity towards and commit violence against individuals who acted in ways which interfered with his access to his daughter when Justice G's home was bombed in 1984. I am satisfied that the accused had the opportunity to commit the offence in the sense that he was not rostered on at work as a fireman at that time. Further, the timing of the explosion is significant. The explosion occurred at Justice G's home in the early hours of the same morning that the accused's proceedings were listed to be heard by Justice G. This was in circumstances where the application which was to be considered could have removed completely or else further restricted the accused's access to his daughter. This is a highly relevant circumstance. I have considered all of the other circumstances that have been proved by the evidence. Although not all of them support a finding of guilt, none of them constitute a reasonable hypothesis consistent with the innocence of the accused. The Crown has satisfied me, beyond reasonable doubt, that the accused committed the offence charged in count 3 of the indictment. That is because I am satisfied beyond reasonable doubt that the accused was the person who placed and detonated an explosive substance at 42 Nerida Avenue, Belrose, on 6 March 1984, with the intention to murder Justice G and destroy his home. There is no need to consider count 4 on the indictment, which is only charged in the alternative to count 3. It is now appropriate to consider whether the Crown has proved the guilt of the accused beyond reasonable doubt with respect to the placing and detonation of the bomb outside the family court building at Parramatta. In 1984, the Family Court of Australia was the only occupant of a building located at the corner of Phillip Street and Charles Street, Parramatta. In 1984, the building's part-time caretaker, Mr. Anthony Laws, lived with his wife and 2 children next door. Just after 10 p.m. on 15 April 1984, Mr. Laws parked his vehicle in the basement car park of the building and then checked to see that all of the doors were secure. He noticed nothing untoward. He entered his home and prepared to go to bed. At a time estimated to be between 10:15 p.m. and 10:20 p.m, he heard a very loud explosion and his house shook. Together with his son, they managed to climb out of the house through a window. They walked to the middle of Charles Street, where each of them observed that the front of the family court building had been extensively damaged. The police were called and arrived quite quickly. In considering the Crown case in relation to this event, I have taken account of a number of relevant circumstances. First, as I have previously concluded, the bombing of the Family Court of Australia building at Parramatta was one of a number of events in the period between June 1980 and July 1985, and particularly March 1984 and July 1985, which did not happen coincidentally. Rather, I have concluded that there was a link between those events. I have previously found that the accused was responsible for a number of these events, which I regard as not occurring as a coincidence. It is a matter of significant weight that this bombing falls into that group of events which were linked and which did not occur coincidentally. Secondly, the accused had the opportunity to carry out the bombing in that he was not at work at the time the bomb was placed and detonated. As well, the accused had sufficient experience and qualifications in welding to enable him to have constructed a pipe bomb, which I am satisfied was used in this bombing. Thirdly, as already established, the accused had a motive. The bombing occurred at a time when the accused's family law proceedings were ongoing and when orders were being made by the judges of the family court at Parramatta which interfered with his access to his daughter. Fourthly, I have previously been satisfied that the accused had a tendency to commit acts of violence against people or institutions which acted in a way which was adverse to his access to his daughter. The bomb at the family court building, which was intended to cause significant damage, if not the destruction of the court building, was an expression of violence towards the Family Court of Australia as an institution. Fifthly, there is no other reasonable hypothesis consistent with the innocence of the accused established on the evidence. Consequently, I have been satisfied beyond reasonable doubt by the Crown that the accused was the person responsible for placing and detonating the bomb at the Family Court of Australia building in Parramatta on 15 April 1984. It is now appropriate to consider whether the Crown has proved the guilt of the accused beyond reasonable doubt with respect to the placing and detonation of the bomb at the home of Justice Watson and Mrs. Pearl Watson on 4 July 1984, which caused the death of Mrs. Watson. Justice Raymond Watson and his wife, Mrs. Pearl Watson, lived together at the unit in Greenwich. On the evening before the explosion, Justice Watson and Mrs. Watson were at home. Both had retired to bed by about 10 p.m. and the lights were switched off at about 11 p.m. At about 9:30 p.m, Geoffrey Reid, a neighbour who had been out, arrived home and walked past the entry to the Watson unit. He did not notice anything untoward. At about 8:10 a.m. the following morning, Mr. Hextell, a Commonwealth car driver, arrived to collect Justice Watson to take him to the family court at Parramatta. Justice Watson, having seen the Commonwealth car waiting outside, went to his study and collected some papers to take with him to work. Mrs. Watson walked to the front door of the unit to open the door for him and say goodbye as he was leaving, as was their usual practice. Justice Watson turned to walk towards the front door. His wife had preceded him, and just as he did so, he saw a bright flash and heard an explosion. Mr. Hextell heard a tremendous explosion and a deafening bang. He was showered in glass from his car window and a window from the block of units. He radioed to his base to call the police. On getting out of his car, he saw debris and rubble on the ground, dust in the air, and that the front of the unit block had been destroyed. He then saw Justice Watson emerging from the debris, obviously injured and in need of assistance. Justice Watson asked him to get his wife, saying, "Quick, Pearl's in there under the door." Mr. Hextell attempted to rescue Mrs. Watson, but was unable to find her. The majority of the unit had been demolished. A post-mortem examination confirmed that Mrs. Watson died from extensive injuries sustained from the blast. The evidence establishes that the bomb was designed and constructed so as to be detonated when the front door of the unit of Justice and Mrs. Watson was opened. For this reason, the offender need not to have been in the vicinity at the time of the explosion. I am satisfied that the accused had the opportunity to commit the offence. The accused commenced his shift as a fireman at the Liverpool fire station at 8 a.m. on the morning of the bomb, that being 4 July 1984. His previous rostered shift commenced at 6 p.m. on 29 June 1984 and concluded at 8 a.m. on 30 June 1984. He was therefore not working the evening before the explosion, which on the evidence is when the bomb must have been put into place. I am satisfied that the accused had a strong motive to place the bomb. As already stated, I am persuaded that the accused held strong feelings of antipathy against Justice Watson for making orders on 6 March 1984, which significantly and adversely impacted on his access to his daughter. As I have already said, I am satisfied that the accused is a man who at the time of this event had a tendency to take violent action against a person who has made orders or otherwise acted to his disadvantage with respect to access to his daughter. I accept that the evidence establishes that Justice Watson was such a person due to the orders made on 6 March 1984. I regard the circumstance which the Crown is entitled to rely upon, that this event did not happen coincidentally with each of events 2, 3, 4, 6 and 7, as being a matter of significant weight. This event is linked to those others in the ways I have earlier found. As I have been satisfied that the accused committed each of events 2, 3, 4 and 7, this is a matter and circumstance which points strongly to the guilt of the accused of these offences. I have carefully considered whether the Crown has satisfied me beyond reasonable doubt that there are no other hypotheses consistent with the innocence of the accused. I have been so satisfied that no such reasonable hypotheses arise on the evidence. I conclude that I have been satisfied beyond reasonable doubt by the Crown that the accused placed the bomb at the front door of Justice and Mrs. Watson's unit. I am further satisfied beyond reasonable doubt that the accused connected the bomb to that front door so that it would explode when the front door was opened. I find the accused responsible for the offence in count 6 on the indictment of the murder of Mrs. Pearl Watson, and responsible for the offence in count 7 on the indictment of exploding an explosive substance and damaging a building with intent to murder Justice Watson. There is no need to consider count 8. It is now appropriate to consider whether the Crown has proved the guilt of the accused beyond reasonable doubt with respect to the placing of the bomb in the car of Mr. Peter Tall on the evening of 9 February 1985 or the early hours of the morning of 10 February 1985. As at 10 February 1985, Mr. Tall was one of 3 tenants living at a house in Northmead. Sometime between 9 a.m. and 10 a.m. on the morning of 10 February 1985, Mr. Tall went outside with the intention of undertaking some mechanical work to his car. His car was parked outside the house on a slightly sloped concrete driveway. Mr. Tall planned to drive his car into the garage, which had a level floor, so that he could safely jack the car up and undertake the work. Mr. Tall sat in the driver's seat and put the key in the ignition. But then he changed his mind and decided he would not move the car into the garage. This decision was, as it turned out, extremely fortuitous and certainly saved Mr. Tall's life. Mr. Tall raised the bonnet of his car and examined the engine on the sloped driveway. He observed loose wires running across the top of the radiator cowling. He followed the wires and found that they were connected to a package upon which he read the words ICI Molinite 1 kilo. He had never seen such a thing before. He had not put the package or its components there. He went inside, told his roommate, and then called 000. I am satisfied that the target of the bomb was the previous owner of the house, Mr. Gary Watts. As earlier mentioned, Mr. Watts's name was recorded in the then current White Pages street directory as still living at the address in Northmead. I reject the accused's submission that Mr. Tall or either of his fellow tenants could have been the targets of this bomb. Mr. Tall, who was about 27 years old in 1985, was working as a staff member at a school at North Rocks which educated children suffering from visual and hearing disabilities. Although there was evidence of a motorcycle accident in Mr. Tall's past, I entirely accept the evidence in this trial that there were no feelings of animosity towards Mr. Tall arising out of this accident. I am satisfied that there was nothing at all in Mr. Tall's life which would give rise to a bomb being placed in his car. The accused submitted, in what I have found to be rather extravagant terms, that because Mr. Tall and his fellow tenants held parties, he lived in a party house and was therefore the target of the bomb. This submission is entirely rejected. There is no factual basis for such a submission, and I regard it as a nonsense. I am equally satisfied that the target was not the new owner of the house, Mr. Geoffrey Evans. Mr. Evans and his family moved to the ACT after purchasing the house, and neither the nature of Mr. Evans' work nor the identity of his initial employer in the ACT provided any reason at all for Mr. Evans to be targeted. I am satisfied that the accused had a motive to target Mr. Watts. I am persuaded that the accused held feelings of antipathy against Mr. Watts for pursuing orders which adversely impacted on his access to his daughter. As established, the accused was a man who had a tendency to take such action when someone acted, as Mr. Watts did, to his disadvantage with respect to access to his daughter. I am satisfied that the accused had the opportunity to commit the offence. The accused finished his last shift at 8 a.m. on 9 February 1985. He did not commence his next shift until 8 a.m. on 12 February 1985. As well, it is a circumstance of real weight in favour of the proof of the guilt of the accused that I am satisfied this accused cannot have occurred. I'm sorry, I'll read that again. I am satisfied that this event cannot have occurred merely as a coincidence with events 2 to 5 and event 7. As I have been satisfied that the accused committed all others of these events, this is a matter which points strongly to the guilt of the accused of this offence. I have carefully considered all of the circumstances to which the accused has drawn attention in submission. In my view, their combined effect does not provide any matter of substance or cause me to have any doubt at all about the guilt of the accused. I conclude that I have been satisfied by the Crown, beyond reasonable doubt, that the guilt of the accused of the offence in count 9 is the only reasonable hypothesis available on a consideration of all of the evidence and inferences to be drawn from it. I find that the accused is responsible for the offence of placing an explosive device into Mr. Tall's vehicle on 10 February 1985 with intent to murder, as reflected in count 9 on the indictment. There is no need to consider count 10 on the indictment. Finally, it is appropriate to consider whether the Crown has proved the guilt of the accused beyond reasonable doubt with respect to the murder of Mr. Stephen Blanchard on or about 22 February 1980. Mr. Blanchard was last seen alive around midnight on 21 February 1980 by his girlfriend, Ms. Julie Ayling. He left her house in his car, wearing his work uniform, and was not seen alive again. His car was parked at his home, where he lived with his father and his sister, Ms. Andrea Blanchard. His work uniform was found on his floor. On 27 February 1980, Mr. Blanchard's body was found by recreational sailors in Cowan Creek, a waterway situated in a remote part of the Ku-ring-gai Chase National Park. Water police retrieved the body. The body was weighed down with 11 house bricks tied together with a nylon rope which had been wrapped twice around his waist. His body was naked and partially decomposed. A white plastic bag had been placed over his head and was tied around his neck with a thin nylon cord. Extensive post-mortem wounds were present from marine predators. Dental records confirmed that it was the body of Mr. Blanchard. A later post-mortem examination confirmed that Mr. Blanchard died from a single gunshot to his head from a .22 calibre weapon. On the one hand, there are some circumstances that indicate the accused may be responsible for this murder. The accused was familiar with .22 calibre firearms. He knew the layout of the Blanchard house and had been inside it on a number of occasions. He did not like members of the Blanchard family. He was familiar with the use of ropes and the tying of knots. He had access to a supply of loose bricks under the former matrimonial home, which were of a kind used to weigh down Mr. Blanchard's body in Cowan Creek. He was not at work over the time Mr. Blanchard was likely to have been murdered. On the other hand, there is considerable material pointing against the accused being involved in Mr. Blanchard's murder. He did not own or have access to a boat at the time. Cowan Creek is a significant distance from where both Mr. Blanchard and the accused lived. It is notable that there were other waterways much closer. Though the accused has been shown to have two tendencies described earlier in these reasons, I am not persuaded that Mr. Blanchard did anything that stood in the way of the accused's access to Trudy. Mr. Blanchard, therefore, would not be an individual to whom the established tendencies would apply. The Crown case is that Mr. Blanchard was shot in his bedroom. It would have been, in my assessment, extraordinarily difficult for one person to remove Mr. Blanchard's body from the house without waking the other inhabitants of the house. The loading of a body and 11 house bricks into a boat also suggests the need for more than one person, as does the depositing of a body tied with 11 house bricks into the water from a boat. It is more likely that at least two people were involved in this murder. There is no evidence that the accused had a close relationship with any other person which would be sufficient to involve that other person in the disposal of Mr. Blanchard's body. On the contrary, the accused's fellow firemen described him in terms as a loner. The existence of a motive is not a necessary element for the finding of guilt of an offence. However, the fact that there is no established motive and no specific ill will between Mr. Blanchard and the accused makes it far less likely that the accused would have committed the offence. Finally, as is clear from the evidence, there is nothing which specifically links the accused to this murder. No one saw him do it. There was no DNA or other trace evidence which connects the accused to the murder. There is no circumstance identified by the Crown which directly connects the accused to the murder. The Crown has therefore failed to persuade me, beyond reasonable doubt, that the accused is guilty of the murder of Mr. Stephen Blanchard. A verdict of not guilty to count 1 on the indictment must be returned. As part of my consideration of the events the subject to this trial, there are a number of named suspects who I have considered as possible offenders, representing reasonable hypotheses consistent with innocence across a number of events. In particular, the primary alternative suspect is Dr. Silvano Mariti. I am ultimately satisfied that none of these named suspects, including Dr. Mariti, committed any of the events in this trial. Although Dr. Mariti was an outspoken and often emotionally volatile critic of the Family Court of Australia, he did not have a motive for a number of the events. He had an alibi for at least one of the events and was subject to a thorough and proper police investigation. Other reasons for dismissing Dr. Moriti and other named suspects as potential hypotheses consistent with the innocence of the accused are set out in my complete judgment and need not be described any further now. It is now time for me to formally return my verdicts with respect to the counts upon the indictment. My verdicts are as follows. Count 1, between 21 February 1980 and 28 February 1980, at Sydney in the state of New South Wales, that the accused did murder Stephen Blanchard. I find the accused and return a verdict of not guilty. Count 2, on 23 June 1980, at Woollahra in the state of New South Wales, that the accused did murder David Opas. I find and return a verdict of guilty. Count 3, that on 6 March 1984, at Belrose in the state of New South Wales, that the accused did, by the explosion of an explosive substance, destroy a building at 42 Nerida Avenue with intent to murder Richard G. I find and return a verdict of guilty. No verdict is entered on count 4. On count 5, namely on the 15th of April 1984, at Parramatta in the state of New South Wales, that the accused maliciously placed an explosive substance near a building, namely the Family Law Court of Australia at 34 to 36 Charles Street, with the intent to damage the said building, I find and return a verdict of guilty. On count 6, that the accused on 4 July 1984 at Greenwich in the state of New South Wales did murder Pearl Watson, I find and return a verdict of guilty. Count 7, that on 4 July 1984 at Greenwich in the state of New South Wales, that the accused did, by the explosion of an explosive substance, damage a building at 175 Greenwich Road with intent to murder Raymond Watson, I find and return a verdict of guilty. There is no verdict entered with respect to count 8. On count 9, namely that on or about 10 February 1985 at Northmead, in the state of New South Wales, the accused placed an explosive substance into a vehicle parked at 12 Kira Avenue with intent to commit murder, I find and return a verdict of guilty. There is no verdict entered with respect to count 10. On count 11, that on 21 July 1985 at Casula in the state of New South Wales, that the accused did murder Graham Wykes, I find and return a verdict of guilty. With respect to count 12 on the indictment, on 21 July 1985 at Casula in the state of New South Wales, that the accused maliciously, by the explosion of molinite, caused grievous bodily harm to Joy Wykes, I find and return a verdict of guilty. On count 13 of the indictment, with respect to the same charge, but which caused grievous bodily harm to Miranda Wykes, I find and return a verdict of guilty. On count 14, with respect to the same charge causing grievous bodily harm to Elaine Wykes, I find and return a verdict of guilty. With respect to count 15 of the same charge, with respect to Sue Schultz, I find and return a verdict of guilty. With respect to the count 16 of the same charge, but causing grievous bodily harm to Peter Schultz, I find and return a verdict of guilty. With respect to count 17, the same charge, with respect to Jodie Edwards, I find and return a verdict of guilty. On count 18 on the indictment, the same offence, with respect to Jessie Mazzotta, I find and return a verdict of guilty. On count 19 on the indictment, with respect to the same offence, but with respect to Susan Rushan, I find and return a verdict of guilty. With respect to count 20, the same offence, but with respect to Paul Hahn, I find and return a verdict of guilty. On count 21 on the indictment, with respect to the same offence, with respect to Rita Ridikas, I find and return a verdict of guilty. On count 22 on the indictment, with respect to the same offence with respect to Jan Toplescu, I find and return a verdict of guilty. Count 23 on the indictment, with respect to the same offence with respect to Lillian Hines, I find and return a verdict of guilty. On count 24 on the indictment, of the same charge with respect to David Winder, I find and return a verdict of guilty. The accused is convicted of each of the offences in counts 2, 3, 5, 6, 7, 9, 11 and 12 to 24 inclusive. The accused is not guilty of the offences in count 1, and no verdicts are returned in respect of counts 4, 8 and 10. I now publish my reasons. These will be provided to the lawyers for the parties, and as I said at the outset, they will be uploaded to the New South Wales case law site for reading by the parties. Yes, Mr. Crown.
Your Honour, in relation to sentence proceedings, we'd asked for some time. We anticipate there will be victim impact statements prepared. I can indicate in relation to my commitments, I commenced a trial in the Supreme Court on the 10th of August, which has an estimate of 6 weeks, but estimates are very difficult, particularly at this time. And another one commencing 12 October. I'd ask for a date in perhaps mid to late September, if possible.
That's not possible. I'm afraid I have another commitment during that period. I had in mind fixing the sentencing submissions to occur on the 20th of August.
Yes, Your Honour.
And then intending that any sentence would be imposed on the 3rd of September. And for the reason that I thereafter have a series of commitments which would prevent me returning to this matter for some considerable period of time.
Well, we'll meet that time.
Mr. Crown, I entirely understand if you personally or your junior are not available. And I take no offence whatsoever if you have to be substituted.
I would expect that that period would allow for the time for any victim impact statement to be.
Yes, very well. Mr. Connolly, do you wish to have anything to say about fixing of sentencing submissions on the 20th of August and sentencing on the 3rd of September?
No, Your Honour.
Very well, thank you. I stand these proceedings over for submissions on sentence until 10 a.m. on 20 August 2020. Thereafter, the proceedings will be dealt with by way of imposition of sentence on 3 September 2020. Please adjourn the court.
All stand.
Your Honour, may the court be vacated so I have an opportunity to talk
No.
to you? You get him?
Yeah, getting it right now. Leonard Warwick.